Anybody representing the government of People's Republic of China? No. Please rise. China Tribunal, final sitting. Sir Jeffrey Nice, QC, in chair. Please be seated.
Mr. Savvy, have you asked whether there's anybody here from the People's Republic of China?
Yes, sir, I did. No one stood up for that.
Good morning, ladies and gentlemen. Good morning, ladies and gentlemen. I'm about to deliver the judgment of the tribunal. Just a couple of other matters before I do so. You'll receive a copy of essentially what is delivered today afterwards, if you want one, and a full judgment will be provided in due course, full being about 3 times as long as the document you will be able to receive today. The judgment will take me about an hour, but probably a bit more to read or deliver. So 2 things. If at any time you can't hear me, put your hand up, because there's no point in being there if you can't hear me. And if I speak too fast or something like that, please also let me know. And also, because it'll be quite some time, if for any reason you need to leave, you are, and come back, you are of course free to do so. You're not imprisoned here. I think that Mr. Savvy may already have invited you to attend to all of what will happen in silence, including the judgment at the end. But it does occur to me as possible that when we, the tribunal members, leave the room, that might be a moment for everyone to give some thought in silence to the suffering of those whom by then you may conclude have suffered. After the delivery of this judgment is over, the tribunal members will not be available for discussion or for interviews and will leave the building, but I believe this room will be available for people to meet and speak. And so, this is the judgment of the tribunal. For over a decade, the People's Republic of China has stood publicly accused of acts of cruelty and wickedness that match the cruelty and wickedness of medieval torturers and executioners. If the accusations are true, thousands of innocents have been killed to order, having the physical integrity of their beings, their bodies, cut open while still alive, for their kidneys, livers, hearts, lungs, cornea, and skin to be removed and turned into commodities for sale. Doctors killed those innocent people simply because they pursued truthfulness, compassion, and forbearance in the case of Falun Gong practitioners and lived lives of healthy exercise and meditation that was seen as dangerous to the interests and objectives of the totalitarian state of the People's Republic of China, which I will hereafter refer to as the PRC. And yet, the PRC has done little to challenge the accusations, except to say that they were politically motivated lies. And governments around the world and international organizations, all required to protect the rights of mankind, have expressed doubt as to the accusation thereby justifying their doing nothing to save those who were in due course, it is said, to be killed to order. If the accusations are to be proved, they will inevitably be likened to the worst atrocities committed in conflicts of the 20th century. But victim for victim and death for death, the gassing of the Jews by the Nazis, the massacre of the Khmer Rouge, or the butchery to death of the Rwanda Tutsis may not be worse than cutting out the hearts, other organs, and the very souls of living, blameless, harmless, peaceable people. But if the accusations are to be proved in this judgment, then the above images and the words that describe them must be minimized. Priority must instead be given to the process where judgments can be made free of emotion and where universal principles of justice can be applied to that process in the interests of any yet living who may be at risk, and to avoid prejudice or prejudgment falling on the People's Republic of China. This is the unanimous judgment of the Independent Tribunal into Forced Organ Harvesting from Prisoners of Conscience in China, a People's Tribunal formed, as others have been, to make a decision about an important issue of public concern not dealt with elsewhere. It was formed by the International Coalition to End Transplant Abuse in China, hereafter ETAC, a not-for-profit coalition of lawyers, medical professionals, and others dedicated to ending what they assert to have been and to be the practice of forced organ harvesting in China. ETAC's main interest has been the alleged suffering of practitioners of Falun Gong, a group whose practices I've already described, but who were regarded by the People's Republic, by the PRC, since 1999 as an anti-humanitarian, anti-society, and anti-science cult. ETAC invited Professor Martin Elliott, Andrew Koo, Regina Paulos, Shadi Sadia, Nicholas Fetch, and Professor Arthur Waldron, who's joining us by video from the United States of America, and who was a fully participating member at all times of the tribunal, who can see us and who we can see on the screen here. Once formed, the tribunal was served by counsel to the tribunal, Mr. Hamid Sabi, Ms. Tabitha Nice, and Mr. Marcus Findlay. All members of the tribunal, counsel to the tribunal, and volunteer lawyers have worked entirely pro bono publico, meaning without payment of any kind. None is a Falun Gong practitioner or has any special interest in the Falun Gong. The tribunal members have maintained distance and separation from ETAC in order to preserve their independence. Investigations into transplant of human organs in the PRC started as long ago as 2001. But the principal non-governmental investigations that emerged in book form have been Bloody Harvest by David Matas and David Kilgour in 2009, The Slaughter by Ethan Gutman in 2014, and a book called The Update for short by those three authors working together in 2016. Going back to 2001, there have been a series of governmental and international investigations and inquiries. Just to list them and very quickly: 2001, a subcommittee of the trade of the US House Committee of Ways and Means; 2007, report of the Special Rapporteur on Torture; 2008, Committee of Torture, UN; 2009, Special Rapporteur on Extrajudicial Executions; 2013, European Parliament resolution on organ harvesting; 2016, report of the Subcommittee of the Human of Human Rights of the Congress, 2016 also a European Parliament written declaration, 2016 a further US House resolution, 2018 a US Commission on International Religious Freedom, 2018 November of last year an Australian House of Representatives Joint Standing Committee. Now, Matas, Kilger and Gutman, the three authors and researchers, have become certain of their conclusions about forced harvesting as a past and continuing activity of the PRC, believing, as Mr. Kilger suggested in evidence to the tribunal in April of this year, that the facts revealed with certainty so far as they are concerned are an inconvenient truth for other countries. Now, over the years, some reports have commented on possible international criminal law offences, but none has pronounced on criminality with any certainty. Had any official national or international body done that, pronounced on the criminality, then we would never have been formed. There would have been no need for us. The tribunal has considered past and present practices, past practices of the kind alleged, if proved, are not to be set aside as historic and more conveniently forgotten. These allegations are of the gravest possible kind that should attract the maximum public censure, if proved, whether or not continuing. Jurisdictions for people's tribunals have been expressed in different ways, dealing with 4 tribunals, of which you may know. The first matter in time to be dealt with by a tribunal was the Comfort Women Tribunal that dealt with the sexual slavery of women to serve the needs, as it was thought, of the Japanese military. The second in time, but the first of these tribunals, was the Russell Tribunal into Vietnam. The third was the 1965 atrocities in Indonesia Tribunal, and the fourth was the 1980s Iran Tribunal, each founding their jurisdiction in different ways. Jean-Paul Sartre, a member of that Russell Tribunal into Vietnam, the French philosopher, said that the tribunal is not a substitute for any institution already in existence. It is, on the contrary, formed out of a void and for a real need. Sartre detected a universal spirit for international justice, starting with the Nuremberg Tribunal, that may have been the driving force for all people's tribunals created since the Second World War, as the world order of international organizations was developing. And the China tribunals, our jurisdiction, is expressly to be found in a gap, just as the Russell Tribunal was, the gap left by the failure of any official body to pronounce on the criminality or otherwise of the PRC's organ transplant practices. The only formal international judicial bodies that might have been required to act on this matter are the International Criminal Court for crimes by individuals, or the International Court of Justice for any alleged breaches of the Genocide Convention by the PRC itself. And both courts are almost certainly powerless in respect of these matters for reasons that may follow or reasons of which you may already be aware. But founding its jurisdiction on that gap has meant that the tribunal does not believe it would be appropriate for it to be making recommendations of a general kind, because there is no gap. There are people, bodies and institutions able, once aware of this judgment, if they accept it, to perform their several duties and to act. The tribunal took evidence on the 8th, 9th and 10th of December of last year and on the 6th and 7th of April of this year. In the first place, ETAC submitted evidence, including a large amount of written material. The evidential hearings were amplified by further evidence after the first hearing and then after the second. The tribunal received advice on the relevant issues of law from legal experts practicing in different jurisdictions. And the tribunal met to discuss its judgment via the internet. All witnesses bar one were heard in public, and the videos of all witnesses, all statements, all written material are available to you now on the website. Invitations to attend the proceedings, to participate in them, to give evidence, or simply to make representations were sent by the Tribunal's counsel, Mr. Savvy, to the ambassador to London of the PRC, to prominent transplant physicians in the PRC and elsewhere, also to the Transplantation Society, and to an organization called the Representatives of the Declaration of Istanbul. Those last two provided statements, but no evidence of any value, and their representatives, as all others invited to assist, have declined to appear. All relevant correspondence on these matters is also on the website. And so it is that all material available to and considered by the tribunal is readily available to readers of the judgment and indeed to the public generally. How did the tribunal conduct its work? In summary, we assessed individual witnesses before us on what's called a free evaluation basis, unrestricted by requirements for corroboration, for example, or exclusion of hearsay evidence. All witnesses, because they had not faced questioning by or on behalf of the PRC, were approached by the tribunal with caution, looking for weaknesses in their evidence, being alive also to the risk of group enthusiasm operating on the minds of witnesses who are Falun Gong supporters, whether or not actual practitioners. The tribunal did not act on opinions of experts or researchers on the final issues that the tribunal is dealing with, but it did rely on their research for other issues where appropriate. The tribunal drew no inferences from the failure of the PRC or any individuals to respond to invitations or to participate. Written material was approached, as for any work of scholarship or research, by exploring the underlying material supporting the document or the video recording for its reliability or unreliability. Tribunal members did not contribute evidence based on their own expertise, save for Professor Martin Elliott, who did on occasions add some medical information on non-contentious subjects. All members of the tribunal thus may be seen as jurors, acting on both fact and the expertise of others, including expertise on the law, in order to make their judgment. And every step of the process has been explained by postings on the China Tribunal website, along with all evidence. So that in this way, the public may themselves engage in the same process of decision-making as the tribunal has done. For law, opinions and advice on the law were received from Edward Fitzgerald QC of the Bar of England and Wales, and Datuk Sivananthan of the Malaysian Bar. They too are posted on the website and referred to in our conclusions. A word about genocide, a crime referred to in public as possibly committed by forced organ harvesting. It is important to note that there is no simple definition in law of the crime, of that crime, that matches the non-lawyer's understanding of it. This may have led to a gap between the non-lawyer citizen's understanding of the term genocide, generating unrealistic expectations of when the crime of genocide may be charged, a gap that is not necessarily helpful or healthy, but unavoidable. The tribunal attempted to honor the principle of hearing the other side by inviting the PRC to contribute, but as you will have heard already, with no success. The tribunal makes conclusions of certainty about the commission of crimes, whether by individuals or by the PRC itself, by applying the test of proof beyond reasonable doubt, both as to the mental state that has to be accompanying a crime and to the acts of the crime itself. And for any lesser strength of conclusions, the tribunal uses non-technical language. Is there a risk of prejudice arising from the fact that members of the tribunal who had most of them no knowledge at all of the particular allegations of forced organ harvesting, but who were aware of the PRC's reputation as a human rights abuser of a very serious kind? There's no doubt that the tribunal members ended the hearing of evidence quite satisfied that the PRC has indeed broken many provisions of, for example, the 1948 Declaration of Human Rights over many years. And the question is, how should they avoid, how should they guard, how did we guard and avoid that prejudicing us in a way that would be unfair to the People's Republic of China? And we did it in this way. Evidence was considered in subject areas or topic areas, with the evidence related to that topic narrowly defined. Conclusion was then reached about the particular topic, and it was a conclusion that would on several occasions have no reference to the Falun Gong at all, and that could be a conclusion that could apply to any other country, a country with a perfectly good record of human rights. And so with a series of conclusions reached in this way that ensured the tribunal avoided the risk of prejudice, there was a series of conclusions that could then be added together, as you will see, to reach our final conclusions on these matters. The first subject area, which we can deal with very briefly, was a background area really on how transplant operations are dealt with in countries that have no problem and deal with the matter properly. And of course, it requires a high level of ethical standards, of supervision, and of openness. And that operated for us, there's of course much more detail of this in the judgment, that operated for us as a background that we could have in mind. On background, we also looked at the very general background to the issues of our inquiry, including, for example, that the practice of Falun Gong was originally approved by the PRC. It became immensely popular. But when in 1999, the number of practitioners had reached 70 million, it was seen as a threat to the belief systems of the Communist Party and indeed of the PRC itself. And so at that stage, a campaign was launched under the auspices of a department called the 610 Office, which had extra legal powers to make arrests, to detain, to torture with impunity those people arrested in an effort to eradicate completely the belief system. There's a great deal of material in written form and in recordings of oral statements that you will be able to find in the judgment. But it was a violent persecution of the Falun Gong. A couple of quotations from people at the head of the 610 office. Whoever is found to be practicing Falun Gong should be secretly arrested and sentenced to a life sentence until death, or beating them to death is nothing. If they are disabled from the beating, it counts as they're injuring themselves. If they die, it counts as suicide. While this persecution started and was developed, another part of general background, which we'll come to again in other ways, was that there was, as one of the either experts or researchers explained to the tribunal, an immense development of the infrastructure for performing transplant operations throughout the People's Republic of China, an expansion of facilities completely without justification if measured by the number of organs that it was known, internal organs that it was known could be available to such transplant facilities. At that time, it's worth remembering, as many of you will know, that China was, PRC was harvesting organs from capital offense prisoners who were executed. But even taking that into account, the scale of development of the infrastructure is or was unexplained. Then this category of evidence, direct evidence of forced organ harvesting. That is evidence by people, and there were a few of them, who were actually required by their employers in the PRC to do forced organ harvesting. Accounts were given of how one witness in particular had to go to an execution site to take the one prisoner appointed for extraction of organs, noting that he had not been killed to death, he'd been shot in the right chest so that his heart was still beating, then required by his superiors to cut deep and fast in order to remove his organs, blood still making itself clear and therefore making it apparent to the witness the man upon whom he was operating was still alive. There was one other, at least, example of that character of evidence, and other accounts of people explaining to others that they had been forced, not forced, required by their superiors to do these things. And then there's indirect evidence of forced organ harvesting, such as one of the many witnesses from whom we heard on arrest being told to give her name and address, or all of her organs would be harvested. Another prisoner giving an account of a sympathetic doctor in the prison where she was held, saying, "Don't go against the Communist Party. You won't even know how you will have died when it happens, where your heart, liver, spleen, and lungs will be taken. You won't even know that either." And the doctor said, tellingly, "Your practitioner's organs are the best. Falun Gong, it should remember, don't drink or smoke, and they do exercise, so that their organs are, it is likely, better than the organs of many other people, particularly those to be found in prisons." So, two categories of evidence about forced organ harvesting itself, some direct and some a matter of inference. The next category of evidence was medical testing of both the Falun Gong and the Uyghurs, who are one of the Muslim groups living in the northwest of China, subject of a great deal of publicity these days, at last, it may be thought, because they are incarcerated in very large numbers, it is said, hundreds of thousands or even a million, in what the PRC has to acknowledge exist, but are, I think, described as education or re-education camps. And the Uyghurs, as with the Falun Gong, in prison, were subject to medical testing. All the witnesses of Falun Gong persuasion who gave evidence to the tribunal were medically tested, and tested in a way consistent with discovering the conditions of their organs. The tests, one witness said, they were said to be a state secret. The results of the tests were never explained to those upon whom the tests had been carried out. And as one witness said, Dr. Trey, an expert, he said, "Why would detained Falun Gong practitioners receive specific physical examination while at the same time being subject to brainwashing?" Plenty of evidence of that. Labor work, torture, or tortured death. The testing, including taking quantities of blood insufficient for use in, say, transfusion, but certainly sufficient for the purpose of testing things about the body and condition of the person being tested. Overall, the evidence of testing of both the Falun Gong and the Uyghurs suggests that the tests were consistent with testing for organ status. Torture. Now, it might be thought that torture in itself is not strictly relevant when we're looking specifically at forced organ harvesting. But the tribunal decided that it was appropriate to look at torture, both for the Falun Gong, the Uyghurs, and also for others, as a specific area of evidence, for a number of reasons, partly because it might help with determining what was the real purpose behind what was being done to minority groups, Falun Gong and Uyghurs, and maybe others as well. For an understanding of the scope of the processes to which the PRC was prepared to put the Falun Gong and others, but the Falun Gong in this case in particular, as part of their objective of wiping out the practice of Falun Gong. Every witness who appeared before the tribunal and who identified as a Falun Gong practitioner had been arrested and imprisoned and tortured when incarcerated. The acts of torture, which occurred throughout the country, are described by various witnesses. They took various forms of physical punishment. You'll be able to read about them. Of course, it's in the nature of things that allegations of torture are unlikely to receive any fully independent verification. But the pattern across the country is consistent in a way that it may be thought is telling. As to the Uyghurs themselves, beyond what I've already said, they are one of the Muslim minority groups in Xinjiang, the Kazakhs and the Uzbeks being the other two, and they've been the focus of a Communist Party, hereafter CCP, crackdown for some time. And one of the witnesses to the tribunal, who's investigated these matters for a very long time, Mr. F.N. Gutman, explained that there were, as he understood it, hundreds of thousands and possibly 1 million Uyghurs in prison, and they were all being medically tested. He said, every Uyghur man, woman, and child. We aren't able to form a final view on that evidence, coming as it does from the single source. Nor are we able to form a concluded view on his opinion that, or his suspicion, that the CCP was building up a national database for organ trade. However, the tribunal has received such a body of evidence of incarceration, torture, and blood testing of the Uyghurs that it would be fair to say that they are clearly a group at risk, and that the world should keep the sharpest eye it can upon them. It is just possible because the Uyghurs are geographically located, as opposed to the Falun Gong, who were dispersed throughout the country, that if there is international action to be taken, it might be a little easier to serve in their protection if protection is needed than it has proved to be over nearly 2 decades for the Falun Gong. There was evidence as well about Christians and Tibetans, but not a great deal of evidence, but it's clear that they also have been incarcerated and tortured in ways consistent with the incarceration and torturing of Falun Gong and Uyghurs. Rape and sexual violence were endemic in all the prisons. And although there's no specific alleged crime to which it relates, the tribunal certainly has been able to conclude that there was orchestrated within the penal system endemic perpetration of sexual violence, including rape, against male and female prisoners, including Falun Gong. The next separate category of evidence is telephone calls to hospitals. The tribunal was presented with evidence of telephone calls from investigators calling hospitals, doctors, medical staff in the PRC, pretending to have a need for a transplant. The purpose being to see whether the person at the other end of the phone call would reveal whether organs were available, if so, at what time interval, and whether the provider of the organ was a prisoner, or in particular, a Falun Gong prisoner. There are 2 groups, at least, of such calls, and I'll just give you a sample of the fruits of one of them. This, I think, was as long ago as 2006, where about 80 hospitals were phoned by this particular investigator. 10 admitted using Falun Gong as the organ supply. 5 said they could retain Falun Gong for the supply. 14 admitted using the organs of prisons. And 10 said that the organ source was a secret, and could not discuss it over the telephone. Now, and incidentally, the last series of phone calls was made as recently as 2018. And those calls also revealed, it's all available on the website. You can look at the schedules and charts of these things, indicating that organs were still available at short notice, which in reality means on demand. There are those who have asserted that there is no value in the calls, who question whether the phone calls even took place and whether the translations of them into English, we're working in English, are accurate. And the tribunal considered those assertions very carefully, but on all the available evidence is certain that the calls did in fact take place and that the translation of these calls are indeed accurate. The next area of evidence which was given very particular consideration by the tribunal was really statistical evidence. Let me try and summarize the position as found by the tribunal. Investigators, and of course the tribunal has then considered carefully the investigators' reports and evidence. Investigators found that the publicly provided material of the PRC on the issue of numbers of donors and numbers of transplant operations performed was unreliable and indeed false. I think I can give you perhaps 2 or 3 examples of how that conclusion was reached. First, at a time when it was said, this is much more recently, at a time when it was said transplant operations were being done only with organs from those who had volunteered under a recently created voluntary donation scheme for their organs to be used. The number of transplants that the PR said it had performed, just under 6,000, contrasted with the number of people signed up, apparently, to be donors as a percentage. An eligible donor, an unattractive concept, but an eligible donor is a signed-up donor who has died. And in any given year, there will only be so many from the pool of voluntary donors who die, and they're, for these purposes, called eligible. And the statistical difference as a percentage between those, it was said in the PRC, who the eligible donors of the total pool of donors, contrasted with the same statistic for America, was 150 times. It was being asserted by the PRC that 150 times the eligibility of donors was arriving, contrasted with a country that's had a voluntary donor scheme for a very long time. There were other examples of completely unacceptable material or information. The voluntary donor scheme itself had apparently rises of 25,000 in one single day, which, as a minimum, would cause doubt or concern. But then there was also concern about the growth of alleged donor numbers, and this was subject to careful statistical analysis, which showed that the growth of numbers matched a mathematical equation, but not the ordinary experience of sociologists or otherwise looking at material of this kind. So, carefully looking at the published material, it was clear that it should be disregarded, and that the issue of how many donors there were, on how many transplant operations were performed, would have to be approached in a different and more distant, triangulated way. And what was done by the researchers was to look at the number of hospitals permitted on their own figures by the PRC to do these operations, 146. The evidence actually shows it was a great deal more. But even taking 146, reflecting in the great expansion of infrastructure, the requirements per hospital on what it would have to be a registered transplant hospital in the way of beds and so on. So the minimum number of beds, the minimum number of hospitals, 146, and making a reasonable and conservative calculation of the number of operations per bed per year led to the conclusion that there was something in the region of, and you'll never get an accurate figure, between 60 and 90,000 transplant operations per year. Vastly greater than the figures suggested by the PRC, because of course once these allegations came to light, it may be thought it would be difficult to justify these very high figures. And a gap that simply cannot be explained. And yet, and by way of example, a man called Huang Yefu, who's one of the important architects of the PRC's transplant capability and expansion, said in 2013, therefore, of 2012, I did over 500 liver transplants on his own. And the director of the Organ Transplant Institute of Peking University said, our hospital conducted 4,000 liver and kidney transplants within a particular year, and that, on their own statistics, would have been one hospital of the 146, actually performing 33% of the total acknowledged operations acknowledged by the PRC. So, thus the statistics. There's also one other aspect connected to statistics, but also to other parts of the general investigation by investigators and indeed by this tribunal. Waiting times for transplantation offered by hospitals and doctors were extraordinarily low. a couple of weeks. It will come as no surprise to anybody reading this judgment to know that received opinion is that a couple of weeks is completely impossible. You cannot find an organ from a volunteer who conveniently dies, horrible word, at the appropriate moment to match someone who's on the phone in 2 weeks' time. It doesn't happen. It can't happen. And yet, a great deal of evidence, people on the telephone and in other circumstances as well, showing that very short waiting times were promised or offered. Dr. Lavi from Israel, a very important witness for the tribunal, because approaching the whole thing completely independently. A surgeon in Israel had a patient with long-term heart condition, waiting for a transplant. And then one day the patient came in and said, I've been told I can go to China and have it in 2 weeks. And Dr. Lavi realized immediately what that meant. It meant that somebody was going to have to be killed for his patient to have the operation as the patient did. Another category of evidence, partly touched on already, is public statements made by the PRC about the Falun Gong. Significance, probably obvious, touched on already, but you will be able to read about or hear about orders to disintegrate them, to ruin them, their reputations, to break them financially, to destroy them physically. Statements made openly or, in any event, never sufficiently covered up, and to have a refrain from those earlier observations of similar statements. Luo Gan, head of the 610 office that was dealing with the eradication of Falun Gong, said in September 1999, whoever is found to be practicing Falun Gong should be secretly arrested and sentenced to a life sentence until death. What about evidence and arguments favorable to the PRC? There have been doctors who have spoken favorably of the PRC's transplantation practices. Jeremy Chapman, Philip O'Connell, Francis Delmonico, and Campbell Fraser. And one at least of these has visited the PRC as a guest of the PRC and found nothing amiss. However, none of these doctors has provided any evidence in the form of records or in the form of recorded conversations with patients or anything of that sort to support or justify their account of the PRC's transplantation practices being satisfactory. And all of these doctors were invited by the tribunal to participate in proceedings and come and tell us what they could of their experience, that they all declined. However, the very last of the government inquiries I referred to was the 2018 Australian committee report. It's called Compassion Not Commerce. And they did assist that committee. The workings of the committee are public, and so, of course, they've been considered by this tribunal, and they've also considered by ETAC. And ETAC gave a critique, at the request of the tribunal, on the contributions made by these doctors to the Australian hearings or proceedings. Of course, ETAC, because they're the very body that commissioned the tribunal and from whom the tribunal normally keeps a clear distance, have to be viewed with caution, not because there's any reason to doubt them, but just because they may have an interest. But nevertheless, their commentary has been considered and carefully analyzed, along with the raw material that these doctors provided. And again, there is no evidence to justify their bland support, if it is bland, for the position of the PRC. Then representatives of the Transplantation Society, which deals with transplantation on a worldwide basis, and the World Health Organization have spoken out on behalf of recent changes in the PRC's organ transplant practices. And the donor scheme, which is started possibly in 2010, possibly still fledgling in 2013. They argue that changes are being made and that external criticism is not warranted. But they appear to rely on statistics provided by the PRC itself, which need analyzing in the way that has been done by investigators giving evidence here, or indeed by others. And they don't seem to have done that. The World Health Organization is, of course, a specialized agency operating in an environment where political pressures may have effect. And so looking very carefully at these doctors' contributions, regretting their absence from the proceedings of this tribunal, but holding nothing against them factually or evidentially on that basis, the tribunal finds nothing one way or another in the things they've said at various times to help in the tribunal's considerations. Government committees of one kind or another, or government spokesmen of one kind or another, are obviously things that could be helpful to the PRC if favorable. To take one example, the government of the United Kingdom has on many occasions dismissed the allegations as not being proved. Statements have been made in the House of Commons and the House of Lords on several occasions. On those occasions, the word analysis has been used, and sometimes the word assessment. So before our hearing in April, the tribunal wrote to the minister concerned, Mr. Mark Field, saying, well, if you have analysis or an assessment, it must be detailed. You're a government department, and it'd be really helpful for us to have it. And would you like, please, to come along and give evidence? You can be the last witness, if you like, in order to comment from the basis of your analysis, your assessment. But unfortunately, that didn't happen. And so far as the British government is concerned, the mere assertion that they have done an analysis or made an assessment that shows that these allegations or accusations haven't been made out is not something upon which the tribunal can act. It is without value. The Australian committee's report of last year was a very substantial exercise, and again, rather like the British government, the Australian government's representative, Mr. Fletcher, gave evidence saying that the allegations were not proved. Of course, the tribunal has considered the workings of that committee and its report, and looked at the videos of Mr. Fletcher explaining that they thought the allegations were false. I think he goes so far as to say. But he also said they didn't have the facilities to do any proper investigation. And overall, again, the tribunal is left with no evidence, nothing concrete of any kind upon which to act. Search where they have for material that might be favorable to the PRC, given that the PRC has not, by presenting itself and arguing its case, have enabled the tribunal more satisfactorily to hear the other side. It's done everything that it possibly can. One point worth considering The tribunal recognizes that intelligence from spying on the PRC, something that will undoubtedly have been done by the UK, the USA, and Australia for sure, might have revealed that the allegations against the PRC were correct or that they were completely false. If false, there must at least be the possibility that the tribunal would have been alerted to the existence of such information, even if it had to be kept secret for some reason. We have not been alerted in any way. And accordingly, the tribunal works on the basis that there is no intelligence, one way or another, available to assist with the issues before us. Another issue, before I come to our conclusions, is the response of the PRC generally, which over these nearly 2 decades has been to do very little, nothing, apart from make bare assertions from time to time that the accusations or allegations are false. Right back in 2001, the first committee hearing that I spoke of in the rapid listing of hearings, there was an account by Dr. Wang Gwoki, who gave a vivid account of what he had had to do as a surgeon, I think, by way of taking organs from someone still alive. It is, of course, impossible that the PRC did not know of that hearing and report on it back to its capital city and its leaders. And the same applies for every other investigation over that 10-year period that I listed. Likewise, all public statements about these allegations made in newspapers, in journals, on the television, will have been reported back to the capital of the PRC by its embassies, because that's what embassies do. And so the very limited response, no response of the PRC, has to be set behind or beside that inferential but overwhelming image of knowledge of the allegations being made. Of course, through a substantial period of that time, the PRC was lying to the world, probably, and to the medical establishments in particular, about its use of prisoners for forced organ harvesting. But that lie, to an extent or completely, vanished when they yielded to international pressure to say that they wouldn't do it any longer. So no need to do nothing because you would have to reveal that lie. How should one approach this sustained inactivity? Well, I suppose you could consider, at least by asking the question, what would happen if in the United Kingdom or the United States of America there were allegations from an entirely credible source of Muslims being tortured to death in Leeds or Philadelphia, 2 cities entirely at random? Would we expect that the states concerned would do nothing except deny it and have nothing to do with such an impertinent allegation, although coming from a reliable source? Well, it's impossible to say. And in the event, and in the end, the tribunal has decided it can make no inference from this long and sustained failure to disprove allegations that have been made with such regularity and clarity over such a long period of time. I turn now to the primary conclusion of the tribunal on whether forced organ harvesting, killing people in order to take out their organs, has been established. Now, making overall conclusions in a matter of this kind is difficult, but it's not impossible. It's difficult, not least because much of what happens in the PRC is obscured, along with, of course, the difficulty created by the disinclination of the PRC to be open with those investigating these issues. And difficulties can translate to doubt and uncertainty, especially if uncertainty is an easier or safer resolution because the truth would be inconvenient. Difficulties can translate to doubt and uncertainty simply because there are so many points of evidence missing. For example, how is it that people, doctors, can come to do these things on what must be a regular basis? But there are many other difficulties listed in the document that will be available to you at the end of this hearing, starting with, if you like, the inability for witnesses to be cross-examined because there's no one to cross-examine them and test their evidence. What about the possibility of rogue institutions? How do you prove the mental state of a body such as the leadership of the Communist Party or of the PRC in the PRC? How do you deal with statements made by a state that is really dealing in the big lie, maybe? How do you get behind the big lie if there has been a big lie, and so on? Well, the simple and indeed the obvious answer to these difficulties and questions is that the tribunal is not concerned about what it does not have that it might have had in a conventional investigation, provided it draws no inferences adverse to the PRC from failure to make things available, or indeed from its lying. What the tribunal must do, just as mathematicians, quantum physicists, engineers do when confronted by an impasse to a known line of inquiry, is to look elsewhere and to examine what is available, and then to follow the deductive trail upon which it is led, testing its conclusions with exactly the same rigor as it would have tested an investigation that had more conventional material available to it. It was with this in mind and with the need to avoid contamination by the tribunal members' knowledge of and judgment indeed about the PRC's human rights record that we approached evidence of, as I've already explained to you, on the basis of silos, if you will, of evidence relating to particular topics. And let me now come back to those particular topics that I referred to, and these are the tribunal's, in reduced form, conclusions. First of all, with the background knowledge of medical practice in mind, what did the telephone calls to hospitals revealing availability and the short waiting time for organs tell the tribunal? Remember that the evidence is being approached not on the basis that it relates to the PRC, but on the basis that it could relate to any country. What would one infer properly from that evidence? The tribunal concluded with certainty that telephone calls were made to hospitals and individual medical staff, including senior surgeons, that the hospitals telephoned were offering organs for sale, that those organs were from people who were alive at the time of the calls and were available to the callers on short notice. Also, that a very large number of transplant operations have been carried out in the PRC, figures up to, well, between 60 and 90,000, leaving an incomprehensible gap. And to achieve the number of transplantations performed before and since that particular estimate, there must have existed another source or other sources of tissue type, that's matching organ for donor and organ for recipient. There must have existed another source or other sources of tissue-typed organs. This in turn shows that there must have existed a body of donors unidentified in PRC material. These conclusions reached above, that's collective conclusions for particular topic areas of evidence, led the tribunal, without giving any consideration to the Falun Gong and assuming again that the evidence related to another country or a fictional country, to the certain conclusion that there was a population of donors accessible to hospitals in the PRC whose organs could be extracted according to demand for them. What about the evidence of direct and indirect, or rather the direct and indirect evidence of organ harvesting and the evidence of medical testing? Conclusions of certainty that the tribunal reached that forced organ harvesting had happened in multiple places in the PRC and on multiple occasions for a period of at least 20 years and is continuing, and that medical testing of groups, including the Falun Gong and Uyghurs, was related in some way to the group concerned because other groups were not tested, other prisoners were not tested. The methods of testing are highly suggestive of methods used to assess organ function, ultrasound, for example, and no explanation has been given for the testing, none. So you combine those conclusions with the previous conclusions, and that led the tribunal inexorably to the conclusion that there has been a population of donors accessible to hospitals in the PRC whose organs could be extracted according to demand for them, coinciding with the long-term practice of the PRC to do forced harvesting, and with many Falun Gong and Uyghurs being compelled to have medical tests. The logical progression of individual conclusions. Turning next to the conclusion about torture of the Falun Gong and indeed the Uyghurs, and the evidence of the public statements made by the PRC, conclusions that took this form, that acts of torture generally reveal an overall consistent attitude and approach of the Chinese state, PRC state, towards practitioners of Falun Gong, systematic in nature, designed to punish, ostracize, humiliate, dehumanize, demean, and demonize practitioners of Falun Gong into renouncing and abandoning their practice of it. And that acts of torture have been inflicted on Uyghurs and generally reveal an overall consistent attitude and approach of the PRC towards Uyghurs, which is again systematic in nature and designed to punish, and so on. And third, from these categories of evidence, that the PRC and its leaders actively incited the persecution, the imprisonment, the murder, the torture, and the humiliation of Falun Gong practitioners with the sole purpose of eliminating the practice of and belief in the value of Falun Gong. Adding these conclusions to those previously reached makes it clear that the PRC would have no difficulty in committing the Falun Gong to any fate, and that they would readily use them as the population of donors, they could readily use them as the population of donors accessible to hospitals in the PRC whose organs could be extracted according to demand for them by means of forced organ harvesting. So this step-by-step process leads to this. There's a clear evidence of a supply chain of organs over many years from an unaccountable source. The fact that the Falun Gong, once incarcerated, could be a usable source, and there being no other identifiable source, the tribunal is certain that it was indeed the Falun Gong who were used as a source, possibly the principal source, of organs for forced organ harvesting. The remaining categories of particular evidence about individuals like Huang Yefu, you haven't heard much of him, evidence about particular phone calls to leaders of the PRC and CCP, which on their own would almost amount to confessions. Those additional areas of evidence do nothing to displace the conclusion reached, rather the reverse. And indeed, those conclusions fit with the overall conclusions reached by considering the overall background, which I refer to as the second element that we considered. And that background evidence was the subject of a conclusion by the tribunal that Since 1999, the PRC and the Communist Party, the CPP, regarded practitioners of Falun Gong as unworthy of any of those universal rights that attach to human beings by reason of their humanity, simply to maintain their power and authority over the Chinese people. And coincidence with the developing persecution of practitioners of Falun Gong over time has been an enormous, unexplained provision of transplant hospitals in the absence of a voluntary donor system at that time. The tribunal does not have sufficient evidence to reach a conclusion of forced organ harvesting having happened with the Uyghurs. The vulnerability of the Uyghurs to the will of the PRC I've already touched on, and the vulnerability of them being used as a bank of organs is obvious. In reaching its conclusion, the tribunal has not, in the event, had to apply its knowledge of the multiple breaches of human rights law generally for which the PRC is known to be culpable, although it would be disingenuous at this stage of the tribunal's conclusions not to acknowledge that there is nothing inconsistent between the tribunal's conclusions and the PRC's human rights record. Continuity of forced organ harvesting, has it ended? Evidence of the most recent availability of organs on demand is to be found in telephone calls of 2018 and in a Korean film of 2017. They are not in themselves sufficient to prove continuity of forced organ harvesting on the same scale, although they certainly do nothing to disprove it. More important is that the system has been in effect for years, despite international evidence-based concerns and criticisms and research asserting that the practice is proved. There is thus no particular reason for it to stop, and many people's livelihoods in the PRC depend on it. Further, it is clear from the evidence of torture by those who were imprisoned but not harvested that the authorities had objectives behind the overall treatment of members of Falun Gong other than the purely commercial purpose of harvesting and selling the organs. And further still, it would appear probable that access to a supply of organs has been one of the reasons that the PRC has been able to become so formidable in the skills required of transplant surgery, and thus to rise, subject to the shadow of these allegations, in the estimation of transplant surgeons around the world, several of whom support the PRC in public, as we have heard. There are maps, I'm not sure whether they're on display, but there are maps which identify all the hospitals spoken of by those tortured and medically tested, and those called by telephone in the telephone calls of significance. And so the tribunal is satisfied that the practice is continuing and that it's on a widespread basis. It should be made clear that it gives the tribunal no pleasure to reach this conclusion, to which it is driven by evidence and the application of reason and logic, together with its appraisal of witnesses who gave evidence. The conclusion shows that very many people have died indescribably hideous deaths for no reason, that more may suffer in similar ways, and that all of us live on a planet where extreme wickedness may be found in the power of those, for the time being, running a country with one of the oldest civilizations known to modern man, which ideally we should be able to respect, and from which we should be able to learn. Conclusions on criminality. As a preface, it might be thought bizarre to observe that if forced organ harvesting by a state or state-approved body was established by strong evidence in a court with jurisdiction covering individual or state responsibility, and that court were to say that for some technical reason the case could not be pursued, that would be bizarre. On hearing that, the citizen would realize that the world order offered her or him no protection through legal processes, and that impunity was fully in place in the state concerned. The clear reality is that once any court is seized of such evidence as being available to this tribunal, it would know it had to find jurisdiction to act in accordance with its statutes and rules, because to do otherwise would have it condemned. This certainty is one that confronts uninvolved states around the world, wherever they are faced with strong evidence of the criminality of other states, they would prefer never to have to refer such evidence to legal authorities, manifesting denial of David Kilgour's inconvenient truth. Once facts as grave as those alleged and accepted here do reach a proper court, then that court will find a way to act. The issue will always be how to get a case to a court, and then which crime or crimes to be charged. The tribunal comes to the following conclusions based on its factual conclusions spelled out above and on the basis of legal opinions and advice received. As to genocide, the tribunal has no doubt whatsoever that physical acts have been carried out that are indicative of the crime of genocide. Reviewing the definition of genocide found in the Genocide Convention and repeated in what's called the Rome Statute of the International Criminal Court, the tribunal is certain that there's been killing of members of a group, there's been caused serious bodily or mental harm to members of a group, that there's been deliberate inflicting on the group of conditions of life calculated to bring about the group's physical destruction in whole or in part. And the tribunal also finds, in relation to the legal understanding of that term group, that both the Falun Gong and the Uyghurs do constitute respectively a group. Further, they belong to one or more of the groups that are specifically identified in the Genocide Convention as deserving of protection, namely a national, ethnical, racial, or religious group. In order to find criminality, there must be a conjunction of both physical acts and mental intent. The question to be asked by the tribunal is whether the crime of genocide has been committed by way of forced organ harvesting of prisoners of conscience. And to arrive at that conclusion, the conclusion that a crime of genocide has been committed, such forced organ harvesting must have been carried out with the specific intent to destroy in whole or in part those groups. The tribunal has not been able to find the requisite specific intent. The tribunal notes, of course, the intention of eliminating the Falun Gong as enunciated by General Secretary Jiang Zemin to the Political Bureau of the Central Committee of the Communist Party in June 1999, the 20th anniversary of which has just passed. Separately, the tribunal notes the development of the market for organ transplant surgery with its huge money-making potential. How and when these two separate lines of events met and merged is not clear from the information and evidence available to the tribunal. And this, in turn, led to the tribunal being unable to conclude with certainty so as to be sure of the very specific intent behind forced organ harvesting of prisoners of conscience. And what concerned the tribunal, in part, was the fact that some practitioners of Falun Gong and some Uyghurs who, while having suffered arrest and detention, were nonetheless released, notwithstanding that they made, with respect to Falun Gong, no promise nor given an undertaking to cease the practice of Falun Gong. Sometimes repeated arrest and detention. Why so? Why was this allowed to happen if the physical and biological extermination of the Falun Gong or of the Uyghurs was the ultimate goal of the Communist Party or the PRC? Their release should not have occurred. If, however, the goal was primarily organ harvesting for profit, then different considerations might apply. And as cautioned by lawyer Datuk Sivananthan, the intention to forcefully harvest the organs for sale for sake of profit is not the same as an intention to forcefully harvest the organs to bring about the physical or biological destruction in part of a whole or a protected group. Given that there were no participation of representatives of the PRC or the CCP, the Communist Party, in these hearings to address this issue, and given that no evidence, explanation has been offered to otherwise account for the release of persons detained, the tribunal is constrained thus from concluding that the crime of genocide had occurred. An alternative argument that was considered by the tribunal was that it was not necessary for the determination of the crime of genocide that some of the Falun Gong and Uyghurs were or were not released and or allowed to leave the PRC, given that the definition of genocide only required that acts of genocide were carried out with intention to destroy a group in part, not in whole. Well, the tribunal noted it was possible to characterize what had occurred as the implementation of a policy to develop the market for organ transplant, where Falun Gong and Uyghurs served, unfortunately, as a ready and rich resource to meet that demand, such that infliction of forced organ harvesting on these groups was not primarily motivated by the intention to exterminate them. Whether or not, despite that, those responsible for the harvesting, forced organ harvesting, had the requisite mental state or intent to constitute the crime of genocide is not clear. And whether what's called a knowledge-based approach to criminal intent to commit genocide could be attributed to them is also unclear, and as advised by Mr. Sivananthan, fraught with legal uncertainty. I turn to crimes against humanity. Adopting the definition of crimes against humanity as set out in the Rome Statute, the tribunal is certain so as to be sure that attacks have indeed been directed against the Falun Gong and the Uyghurs in the PRC, with actual knowledge of the attack by state actors of the government and by the PRC. Indeed, these attacks are state-sponsored or state-sanctioned, and pursuant to them and pursuant to or in furtherance of a state policy to commit such an attack or attacks. We agree with the advice given by Mr. Fitzgerald QC that forced organ harvesting is sufficient to constitute an attack. The tribunal is further satisfied that such attacks are widespread or systematic. The tribunal is also satisfied beyond reasonable doubt that one or more of the following acts have been committed on the Falun Gong and the Uyghurs in the PRC: murder, extermination, imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law, torture, rape or other forms of sexual violence, persecution on racial, national, ethnic, cultural or religious grounds that are universally recognized as impermissible under international law, and enforced disappearance. Taken together, such attacks and such acts constitute crimes against humanity, which the tribunal is certain beyond reasonable doubt, or in the other formulations, so as to be sure, has occurred. Torture, based on the findings of the tribunal above and in relation to torture in the context of crimes against humanity, the tribunal is of the view that it is beyond reasonable doubt that acts of torture have occurred. In the context of the Convention Against Torture, the tribunal is certain of two things. First, that they were acts by which severe pain or suffering, whether physical or mental, was intentionally inflicted on the person punishing her or him for an act he or she has committed or is suspected of committing, or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public official or other persons acting in an official capacity. And secondly, the exception for torture in respect of pain, suffering arising only from inherent in or incidental to lawful sanction doesn't arise. It's clear that the type of treatment experienced and described by witnesses who appeared before the tribunal were in no way justified by that exception. In relation to two other groups, Tibetan Buddhists and people called House Christians in the PRC, the tribunal is unable to come to any finding, as there was insufficient evidence presented to satisfy the elements of the possible crimes under consideration. Actions to be taken. As already mentioned, the tribunal is acutely aware, both having regard to legal opinions and advice and from its own collective knowledge, of the jurisdictional hurdles that lie in the way of prosecuting crimes contrary to international law of genocide, crimes against humanity and torture. In relation to the crime of genocide, and notwithstanding the conclusion arrived at by the tribunal, it is still open to the UN General Assembly to request from the International Court of Justice an advisory opinion on the very same issue of forced organ harvesting in the PRC and whether it constitutes genocide. There would be no need for the PRC to consent to such a request at the International Court of Justice. Resolutions calling for such action may be moved by or on behalf of one member state for consideration and, if sufficiently supported, adopted by the General Assembly. Action at an international level could also be founded on the basis of the responsibility to protect, known as R2P, That's a political commitment endorsed by all member states of the United Nations, including the PRC, in 2005 to prevent genocide, war crimes, ethnic cleansing, and crimes against humanity. Respect for norms and principles of international law mandate national governments, regional and international communities to initiate action to intervene in such situations. However, intervention requires approval by the United Nations Security Council, of which the PRC is a member that can exercise a veto. It will also be open for the UN Human Rights Council to consider the matter based on a resolution proposed by one or more of its 47 member states. Subject to a majority voting in favor in the Council could create a mandate for a special rapporteur to investigate these allegations of forced organ harvesting of prisoners of conscience in the PRC and to report back to the Council whether the crimes of genocide, crimes against humanity, and torture have indeed been committed. Despite the time this would inevitably take, this could be one course of action to be given some priority without limit to the importance of others. The UN Working Group on Arbitrary Detention might also have a role if necessary. Cooperation could be established for an interview with a known arbitrarily detained person, but there is a risk in identifying too many international interventions that none will receive proper focus and all might then fail. Apart from action at an international level, initiated by national governments or possibly others, domestic action in such matters is possible by asserting universal jurisdiction powers established in some national courts by national legislation or by international law to permit individual plaintiffs to file legal actions against particular individuals or even against a sovereign state for acts or conduct that may constitute genocide, crimes against humanity, or torture. The Tribunal is aware of an action commenced in and accepted by the National Court in Spain in 2013 by a group of Tibetan exiles seeking to bring, amongst others, former Chinese leader Jiang Zemin to justice for acts of genocide in Tibet. As a result, the Spanish court issued an international arrest warrant for Jiang. The Tribunal, however, is not aware of any recent developments in this case. Efforts have recently been put in train by lawyers in Melbourne, Australia, another example, to have Aung San Suu Kyi prosecuted for crimes against humanity in respect of the Rohingya Muslims suffering. Present progress unknown. The Tribunal, however, has emphasized that its principal role is to identify whether it is satisfied beyond reasonable doubt that crimes have been committed, rather than to identify with certainty any individuals who may have committed crimes, and having noted possible courses of action that the governments could take, the Tribunal leaves to citizens, activists, and motivated politicians the task of pressing governments to do what may be done, or what may be thought the duty of those governments to do in the face of any revealed wickedness of the kind shown in any finding that forced organ harvesting has happened or is continuing to happen in the PRC. The Tribunal notes with disappointment how both the United Kingdom and Australian governments have expressed no desire properly to test the allegations by themselves or through the United Nations. I refer to the response of the United Kingdom to this tribunal and to the Australian report of 2018. It might be expected that allegations such as these, as grave as any on a death-for-death basis that were proved in the worst political mass murders of the 20th century, might be thought worthy of the most urgent and potentially beneficial action that the world order would allow. Not to be expected, it seems, of the United Kingdom and Australia. As it happens, and as noted in the papers, the United States of America in 2016 took a very different line, close to the point of saying that these things definitely had happened. So far as governments are concerned, the Tribunal reverts to what it has said about the PRC's failure to engage with the allegations being made for such a long period of time. By their failures ever sufficiently to investigate the allegations as to find them proved, governments around the world have been able to justify doing little or nothing, and certainly not initiating one of the processes that could bring these allegations to formal judicial determination. And over this time, the PRC may have deserved better of itself than to let an existing practice continue and grow. Countries testing grave allegations and not letting the PRC escape oversight could have helped the PRC to understand that the practice in which it was engaged had to stop if it was to find a place in the world as something more than an enormously powerful commercial partner and competitor of other states, large and small. Tragically unchecked action allowed many people to die horribly and unnecessarily in the service of objectives that successors to the present PRC leaders may come to recognize were never essential to the well-being and growth in stature of their state. Finally, on actions to be taken, assuming governments do not do as it might be thought they should, the usually powerless citizen is, in the internet age, more powerful than she or he may recognize. Criminality of the kind revealed may allow individuals from around the world to act jointly in pressurizing governments so that those governments and other international bodies are unable not to act. But the citizen as shopper should not be overlooked. Boycotting of goods started before the American Revolution by Americans in respect of English products and has been an intermittent force ever since against such countries as Israel, America, and South Africa. The effect of boycotting is always uncertain and may be limited. But more, or perhaps most significant for these events, is that for much of its customer base, the PRC is a very long way away, and an individual citizen's conscience-driven response to knowledge of what her or his neighbor is doing may be in inverse proportion to how near that neighbor is. One final observation. As explained above, the tribunal sees no need to make general recommendations because there are plenty of individuals, bodies, and governments that should act given the conclusion that the tribunal has reached. However, this much can be said, and it is again no pleasure for the tribunal to be saying it, not least because it may be an observation long overdue from responsible governments. In the wonderful, diverse, cultured land of China, where today the PRC and the CCP may be involved in many more areas of life than is the case in some other countries, any who interact in any substantial way with the PRC, including doctors and medical institutions, industry and businesses, most specifically airlines, travel companies, financial services businesses, law firms, pharmaceutical insurance companies, together with individual tourists, educational establishments, and art establishments, should now recognize that they are, to the extent revealed in this judgment, interacting with a criminal state. We will rise.
Thank you, everyone. The proceeding is complete now.